Good evening. Hi, everyone. I am Bonnie Jean Feldkamp from the Louisville Courier-Journal. I am the opinion editor, and I'm the one who gets all of your wonderful letters to the editor, which I hope you'll continue to send to me. Tonight, we are together to talk about family court. We have our judicial candidates for family court for Division 5 right here behind us. And you might be asking, didn't we do this last year? Didn't everybody get voted for and everybody's on the bench now? Yes. But we're back because Judge Tara Hagerty retired early on June 1st. And so we need to fill that vacancy. And tonight we're going to hear from each of their judicial candidates with pre-selected questions that was a collaborative effort for all of the sponsors involved, including the Louisville Courier-Journal, the League of Women Voters, the Louisville Bar Association. And we are so grateful to have this community collaborative because family court is super important. More everyday people will go through family court than we realize. So we are going to get started, and we have 6 candidates. We have 7 questions. We're going to open the evening with a 90-second opening remarks from each candidate, and I'm going to start that now. We will go straight down the line. The candidates are at the tables as they will appear on their ballot. So hopefully that helps you put some names with faces when you walk into that booth while questions are being asked and answered. So Emily Craddock, let's start with you. 90 seconds.
Sure. Hi, my name is Emily Craddock, and I just want to start out by saying thank you to all of the sponsors tonight. I know it's hard on a down ballot race to actually know who the candidates are and really get an idea, so I appreciate that. Also, special shout out to the Seneca High School students who are volunteering here tonight. To give you a little bit of information about myself, I grew up in the south end of Louisville. To answer the kind of quintessential Louisvillian question, I went to Manual High School. After that, I went to U of L for undergrad and law school, graduated there from honors. And then after that, I worked at the largest domestic relations firm for a few years. And then in 2017, I opened my own family law firm. Kind of on a personal note, I am married to my law school sweetheart, and then we have 2 little girls together. A part of my platform is that I want to be fair, focused, and put families first. What I mean by fairness is I want to treat everyone equally, regardless of race, sex, gender, or socioeconomic status. I want to be focused on reducing the current backload of cases, and then I want to put families first. And what I mean by that is making sure that at the end of the day, typically families come to the family court system in a state of dysfunction to some extent. And so I want to make sure that at the end of the day, when the orders are entered, they're in a better place than they were when they started in the family court process. So I'm Emily Craddock. Thank you.
Thank you very much. Mason Treneman.
Hello, I'm Mason Treneman. Thank you all for being here. I am a former family court judge, served as a family and district court judge for about 5 years, and asking to return as family court judge. Since this race began about 6 months ago, people have asked, why on earth would you want to go back to family court? You make a really good living in a successful private practice. You're going to give up a lot of income and go to a place that is admittedly as high stress as just about any job there is. I see Judge Cunningham nodding his head back there. That's a fair question. To understand why I'm trying to return to family court, you have to understand about me and who I am. Like many people who appear in family court, my parents were babies when they had me. My mom was 15 and my dad was 17. Over the next 9 years, they had 4 other children. So by age 24 and 27, they had 5 kids. My dad was working 2 jobs and they didn't have much money. They got divorced pretty soon thereafter. Not surprisingly, when you've got 5 kids living with a single mom who's 25 years old, we didn't have much. I'm the kid who had holes in his shoes, Goodwill clothes, and free lunches. I know what it's like to be that kid that is made fun of for those things. As a grown-up, I taught my kids the value of public service. We've gone to Guatemala on mission trips. We have had 7 foster babies in our home, medically fragile, drug-exposed foster babies that we've raised. Public service has been a part of who I am every day, and I make a difference in family court every day. I think as a family court judge, I can make a difference on a much, much broader scale.
Good evening.
Thank you.
Go ahead.
No, thank you very much, Judge Laura Russell. Go ahead.
Good evening. I'm Judge Laura Russell, and I do want to thank our sponsors. They're all listed back here. Also want to thank Bonnie Feldkamp from the Courier-Journal for being here. In May of this year, Governor Andy Beshear appointed me for a vacancy in Jefferson Family Court. I appreciate his trust and confidence in me and allowing me to serve the families of Jefferson County. I'm a graduate of the Brandeis School of Law at the University of Louisville. I've practiced law for over 2 decades. 15 plus of those years have been spent in family law. In my courtroom, I'm trying to make a difference by having a fair court and stronger families. I'm doing that in my courtroom. I make sure that everybody has an opportunity to be heard, treated with respect, and domestic violence victims get relief, and families have resources when children have to be removed from the homes. I'm a wife, I'm a mother, I love the community, I'm raising my family in this community, and as a testament to my qualifications, the Citizens for Better judges chose me as the most qualified candidate in this race, and that was an honor. So I'm grateful to be here tonight. I'm grateful to be your family court judge. Hope that continues, and thank you all.
Thank you, Judge Russell. Jessica Stone.
Hi, I'm Jessica Stone, and I'm here for you and to serve you. I'm asking for your vote on November 7th to do that. I believe in working families. I believe in helping our kids, especially in those moments where they are going through difficult transitioning periods. I believe cases should be dealt with expeditiously, and I believe in minimizing the cost and time of litigation. I believe these things because I've been through it. As a single working mom, I have been through the system, been through the process, and have been in your shoes. Now, as a lawyer running for judge, I have a plan to fix the process and make it better for families. So vote Stone on November 7th. It's a rock solid choice.
Thank you. Allison Spencer Russell.
Thank you. I have to apologize because I lost my voice at noon today.
Perfect timing, right?
Right. And I can tell you the reason why I probably lost it is because I spent the entire morning interviewing a mother in a contested child custody matter. The reason I was interviewing her is I wasn't her attorney. I wasn't her child's attorney. I wasn't the judge. I wasn't the mediator. I'm what's called a friend of court. And that is a person that the judges trust so much that they appoint them to interview the parties, interview the child, watch the child interact with the parties, talk to any sources, grandparents, teachers, pediatricians, counselors, write a report and recommendations as to what I think should happen in the way of custody and parenting time. So that's one of the things I do in my practice is I'm appointed by courts to serve as a friend of court to help guide them as to what's in the child's best interest. Aside from that, I've done pretty much anything you can possibly do in family court. And, I've represented victims of domestic violence, people accused of domestic violence, people seeking child support, people who want their child support reduced, people with multi-million-dollar marital estates, people with nothing who just want a fast and easy divorce. You name it, I've done it, and I've done it exclusively for the past 14 years. I've dedicated my life to family court. I think I could make a difference.
Thank you. Claudette Patton.
I'm Claudette Patton, and I believe that family court is one of the most important positions that is in this community. Family court is a place that challenges for families come before the court for decisions of family disputes. This venue tonight, there is no place that I'd rather be than here with you tonight for us to talk about the challenges and the issues that are important to you, because family court touches every single person in this room and in this community. I'm honored to be in this platform with my friends and my colleagues who are all tremendously experienced. We all have great experience, and family court is part experience, but is also a part of core values. And so tonight, I want you to get to know me a little bit better about the core values that I think belong in family court. One of those core values is that family court is fairness. Every decision, every case, every person should be treated with dignity and respect and have a fair outcome every single time. The second one is active participation. A judge should participate with family court for a positive and healing outcome for a win-win, especially for children. The third core value is protection. Protection from violence, because every person deserves protection under the law.
Thank you. Now we're going to go into our questions, and each question you will have an opportunity for a 60-second answer. Now we are going to start our first question with Mason Treneman. Families from diverse personal, economic, and social backgrounds will come before you in court. What have you learned from your professional and community experiences that will assist you in presiding in family court? 60 seconds.
Start with community experiences. My grandmother she'd tell you 5 feet. She was 4 foot 9 inches, weighed between 90 and 100 pounds as she went up and down in weight all of her life. She went to the grocery store with my mother when she was little, and they had a girl from school with my mother, and they went in to get a piece of penny candy. And they told my grandmother that she could stay and my mother could stay, but the little black girl, except they used a different word, had to leave. My grandmother left. She changed grocery stores, and she walked because she didn't drive. She walked back and forth to a grocery store that was about half a mile from the house because she would not go back into that store any longer. I heard that story as a little boy. I grew into that because when people look different, they shouldn't be treated differently. Because they act different, look different, or have a different set of values than me, they still deserve to be treated with respect. As a family court judge, I treated everybody who came before me with patience and respect. When they walked out of that courtroom, agree or disagree, they knew they had been listened to. That's what we need to do as a family court judge.
Thank you. Judge Laura Russell, same question. Would you like me to repeat the question?
Do you mind?
Sure. Families from diverse personal, economic, and social backgrounds will come before your court. What have you learned from your professional and community experiences that will assist you in presiding in family court?
Well, for the past 5 months, I have been presiding over these families. I've had Nepalese families, I've had Nepalese interpreters, only Spanish speakers in my courtroom, and so I have been working with these individuals, and I can't tell you how important it is, from my perspective, to be able to allow people to be heard, whether it's in English or any other language that our language line provides. And I've worked with low-income individuals before I was a judge at the Louisville Bar Association. I think it's so great for people to have access. But I treat everybody the same in my courtroom. I'm fair. I want to hear what everybody has to say. And I think it's so important for people to be treated with respect. And I think that if all of those take place, then I think that no matter what my decision is that day, I think that everybody leaves knowing they were heard. And I think people just want to be heard. That's what I found as a judge. So in my courtroom, everyone is treated fairly, and I think fair courts make stronger families.
Thank you. Jessica Stone, would you like me to repeat the question?
I think I got it.
Okay.
So from a professional standpoint, I began my career working as a family court practitioner, and I took on over 100 assignments from Legal Aid Society representing victims of domestic violence that were going through that process and getting protective orders. So they qualified for legal aid because of their low income status. I also work every day at the Hall of Justice as a prosecutor, and we don't just deal with defense attorneys, we also deal with pro se litigants, meaning they probably cannot afford an attorney. So we walk them through the process, give them their rights, and treat them with respect and dignity, like Judge Russell said. From a personal standpoint, I have also been through it. Once I left an abusive marriage, I was on public assistance. I had to explain today to someone that had not before in their life. They asked how much was on a food stamp. Well, I know now, having gone through that process, that it's a card, and was able to describe that to them. So both professional and personal.
Thank you. Allison Spencer Russell, would you like me to repeat the question?
No, ma'am.
Okay.
Every Thursday, I call it donate my time, but I do get paid $500 per case. I am a court-appointed parent's attorney and guardian ad litem in cases where the cabinet has removed children from parents' homes. And that actually is every walk of life. You know, abuse, neglect happens irrespective of income or location. But with that said, it has expanded my horizons, and I have met a lot of people that I normally would not come into contact with had I not been appointed to this position. You know, additionally, I was endorsed by CFAIR, which is the organization that works towards racial justice, the fight against discriminatory laws, and more support for immigrant families. So I kind of pride myself on just being, you know, open to other cultures and wanting to learn every day of my life about them.
Thank you. Claudette Patton, would you like to repeat the question?
No, thank
Okay.
you, Bonnie. I believe that my personal experience and my professional experience has had the opportunity to meet people from all walks of life. In my own personal experience, I grew up in Fairdale, so I did not grow up in an affluent family. I grew up in a working class family. My mom was a school bus driver, and my dad was a laborer at 16th and Lee at Cohart Refractories. So I know what it's like to be the girl whose dad was on a picket line for 18 months and had no work, and we had to eat cornbread and beans for over a year together because we were living on my mom's salary as a school bus driver. I'm adopted, so I know that families are put together in very unique ways, and that it's not just a bloodline that makes a family. What makes a family is you're caring for one another. I have had a great practice and a diverse practice, from pro bono work through legal aid society all the way to high net worth clients, and you treat each person with the same dignity and respect no matter where they're from or who they are.
Thank you. Emily Craddock.
So the thing that I think is so amazing about our community is it is so diverse. When I was fresh out of college, I was a census enumerator, and I got to walk all around Louisville and all the different communities and get people's basic information. It was a wonderful and eye-opening experience for me to get to go to places I hadn't been to before. And so, you know, professionally in my practice, I represent people on the DNA docket. I represent people that are stay-at-home parents that maybe work at a low-wage retail job. I've also represented people that are millionaires or people that have a lot more assets. I've represented people that don't speak English. I've represented people that come from all kinds of diverse backgrounds. And I think it's so important to remember that in the family court system, that everybody's coming in with their own unique experiences, their own cultural backgrounds that kind of shape how their families look. So, you know, as a family court judge, I think it's so critical to make sure that you have that background knowledge about the culture and the differences in the families.
Thank you. Sure. Our next question, Judge Russell, we'll start with you. Are there family court reforms that you would or would not support? Give me an example of one and why.
Well, I think right now we are trying to make sure e-filing happens in family court. I know the Jefferson County Clerk's Office is really trying to incorporate that. I know the judges have to do it by the beginning of the year, and I think it's so important because it allows attorneys, and if you're signed up on the system, to be able to get orders faster, and you can make decisions right away from that. So that's one, just giving access and being for everybody to be heard and get things quickly. In my courtroom, I only have like 3 or 4 things under submission right now, so I think that's pretty good. So I don't know that there's a backlog, but I think the e-filing system really helps the court and the clerks get things done really quickly.
Thank you. Jessica Stone, what's one that you would or would not support?
Well, I definitely would support not allowing frivolous motions coming before the court. You can, as a judge, say no, and that's what I would plan to do first. Also, getting out orders timely, because it leaves families in limbo, which then can create additional reasons to come and ask for more answers. When you're not given one and you have to wait and wait and wait. I'm talking months, you guys, months. And so that is definitely something that I think is necessary. And then, lastly, enforcing the orders. So when you teach there on the bench also what behavior is expected of you and what you expect from your parties. If a party is allowed to continue abusing the system and not following your orders, what good is a court order?
Thank you. Allison Spencer Russell, what would you support?
Do you mind repeating the question?
Absolutely, sure. Are there family court reforms you would or would not support? Give me an example and why.
Okay. One thing that they just implemented recently was I don't like. As you're aware, Kentucky has a one family, one judge policy. The way family court runs, in case anybody doesn't know, we have multiple different kinds of dockets. Domestic violence, DNA, circuit, and sometimes a family will come before a judge on the domestic violence docket, and then a year later, there'll be a divorce involved. We need to make sure that lands in the same division every time, so we have the same judge overseeing those families. They get to know the family if they're in there all the time, and that just helps for consistency's sake. But we all got an email the other day that said, we're now randomly assigning judges to all cases. It used to be you would go by last name, and you could kind of tell your client, you're going to land in Division 5, you're going to, this is how that's going to go. I don't know how they plan on implementing that policy and keeping track of everything, but that was one thing that was recent, that was minor, that I kind of didn't like.
Thank you. Claudette Patton.
Thank you. I have two things. The first thing is that I believe that we learned from the pandemic that we could be much more efficient in court by the use of Zoom for hearings and for motion hour. And I would return that back to the family court because I believe it's efficient and I believe that it takes care of families. For example, it really hits the pocketbook every time that somebody has to take off work who's an hourly employee. They lose an entire day of pay. Sometimes I've even had clients that have lost their jobs because they had to appear in court. But an employer will allow someone to go to Zoom court for an hour or so away from their job. So I think that it's a win-win-win with Zoom. It's a win for the taxpayers and for the pocketbook of parties. It's a win for our victims of domestic violence because it gives them a protection piece. The second thing that I would implement is we always celebrate when there's an adoption that happens. We don't celebrate usually when we have a return to parent. I want to bring in a celebration when we reunite families and children are returned to their loving parents. It's a victory.
Thank you. Emily Craddock.
Yes. So to me, I think one of the biggest reforms that I would support is something that's a pilot program right now in Jefferson County, which is Recovery Court. So for those that aren't familiar, there's a dependency, neglect, and abuse docket, and a lot of times the parents on that docket have addiction issues. And so in Jefferson County right now, there's only enough funding for 2 of the 10 divisions to have what's called Recovery Court, which is a way to make sure that parents are connected with resources in the community to help them reach sobriety and have their children returned to them. And so that, to me, has been wildly successful in the 2 divisions that it's in on the limited budget that it's on. But overall, I really feel like that is an important and critically important part of helping to reunify families and make our community stronger and better.
Thank you. Mason Treneman.
The first is one that's actually on the horizon and being implemented. That's e-filing that was just discussed. E-filing can be a great thing. I share some concerns, though, as Judge Santry and Judge Goodwin expressed at the last term meeting. We need to make sure we don't cut off pro-litigants. There has to be access to the courthouse for people who don't have attorneys, so we need to protect that. The bigger one for me personally is one I worked on when I was a family court judge before, when I was with the National Council of Juvenile and Family Court Judges. It is on the dependency, neglect, and abuse docket, and it's the equivalent of what we now call restorative justice in many of the criminal courts. We try to bring the players together with some of the recovery court aspects, with many of the treatment aspects, and get people together at the same table. Instead of a confrontational, you go into court, you swear against each other, everybody is stacked for a fight, and you work together under this restorative justice plan. Judge Fitzgerald and I spearheaded that when we were judges together. Unfortunately, in the last 15 years, it has just gone away. It is time to bring that restorative justice concept back to family court.
Thank you. My next question will start with Jessica Stone. It's difficult for domestic violence victims to sit in the same court with their perpetrators. Would you support provisions for their testifying virtually, and why or why not?
Absolutely. I mean, that can't say enough about that, but when a victim is put in the same room as their abuser, it re-traumatizes them. So the fact that we have been able to make technology work for us and allow this protection to victims is absolutely something we should continue doing. That I don't know why there's even a question about it.
Thank you. Allison Spencer Russell.
Emphatically, yes. I was devastated when that went away. We had a lot of victims dropping their request for a protective order and not showing up to court simply for the fact that they had to see that person even down the hallway. So it was a very devastating loss to a lot of victims in Jefferson County.
Thank you. Claudette Patton.
Obviously, my answer to that is yes from my previous question. But yes, I believe that we need to put everything into place to protect our victims of domestic violence, and that includes women and men. Being in the same room with their abuser sometimes is very difficult. And as an attorney who has practiced in domestic violence, one of the worst days is having a client who is trying to testify to her abuse, and the abuser is staring her down, and she goes weak-kneed, loses her voice, and cannot testify and cannot talk. When we have that virtual component in place, we have that wall of protection. The perpetrator is still allowed to cross-examine. No constitutional rights are violated. He or she can still be questioned. Let's keep our victims safe and give them the opportunity to testify with freedom.
Thank you. Emily Craddock.
I believe that all people on the domestic violence docket that appear should be able to do so virtually. I think it's critically important. I've had clients that I've had to sit next to who were shaking because they were within a few feet of the person who committed horrific acts of violence against them. I've had clients that have decided not to come forward on a petition because they were too fearful to be in the same building with someone that had been abusive to them. And so I think it is critically important for the people that appear on that docket to be able to appear virtually. We allow virtual appearances for most other dockets. I do not see why we wouldn't do that. I'm not sure what Judge Russell's rationale was for changing that rule back in June, but I do strongly disagree with it and would immediately change it back so that people could appear virtually.
Thank you. Mason Treneman.
Well, the first thing is, as a term, the term has to make decisions on certain things that happen. So the 10 judges together with Frankfurt and the administrative office of the courts need to decide what's constitutional, what's not constitutional. That being said, my voice on the term would be, this is about the only good thing that came from COVID. We can conduct many things remotely, and that helps people. It helps people keep their jobs, as somebody else talked a few minutes ago. It helps people save money on attorney's fees, and it helps victims of domestic violence be able to testify in a manner where they can testify truthfully, honestly, and not be just traumatized again because they have to walk into the courtroom. So it is a qualified yes, because we do have to understand none of us are fiefdom, and we all work within that system.
Thank you. Judge Russell.
So thank you for that question. I'm glad that this came up, actually. So I'm hearing domestic violence cases every single week. We have a specific day, that's Thursday. I hear about 30 to 40 domestic violence cases every Thursday. I have never, ever, to my knowledge, everybody has always appeared via Zoom, they appear via phone, and they appear via in person. So to say that I've restricted somebody's right to be able to come into my courtroom virtually or in person is just false, and clearly hasn't been in my courtroom. So I think that I respect a domestic violence victim's right not to confront the accuser. So of course, we use all methods in my courtroom, and I absolutely will continue that, and I want people to feel comfortable. And the problem with Zoom, however, is sometimes it disconnects. And my fear is when that happens is that the domestic violence victim won't be able to call back in. And so my fear is that petition will never get heard. That is my only concern with that.
Thank you. Our next question will start with Allison Spencer Russell. As the law requires, will you give custody matters priority, and how will you achieve that?
You gave me the hard one. Like, I'm mean, the rules provide that you have to have it within a certain amount of days. And for many, many reasons, that's not been happening. There's only 10 of us, and there's, I don't know how many cases are per docket, thousands. And there's limited time in the day, there's 5 days a week. You really have to have good docket management skills and trust your staff to manage your docket effectively so that you can get those custody cases heard. I will follow the law. I am an appellate attorney. I know the law. I will follow the law. That's not in question. What's in question is how do we follow that practically and logistically? You really have to know what you're doing in order to make sure that those cases are a priority.
Thank you. Claudette Patton.
Thank you. Absolutely, custody is a priority. Just last year in Jefferson County, we had 115,500 plus brand new cases. That's not even the existing cases on the docket. 15% of that is specifically family court. So when we place priority on custody, we have to make sure that not only we're following the law, but that we are working together as a team. You know, it's not just the judge. You have clerks, you have case managers, you have the staff within the courtroom to help and assist in being efficient. And with the use of hybrid, such as Zoom and other technology, we're able to be more efficient and make sure that we're keeping custody a priority and upfront in our family court cases.
Thank you.
Can you repeat the question?
Absolutely. As the law requires, will you give custody matters priority, and how will you achieve that?
Sure. So, yes, to answer the first part, I will follow the law and give matters of custody priority. I think that, you know, since the wave of COVID, we've been able to use technology to our advantage, and there's ways to make sure from docket management perspective that you have enough time in the day to actually give those cases priority. So, for instance, in Fayette County, they allow for emails to get sent out, so when you're scheduling a hearing, you can kind of see the judge's entire calendar and be able to select a date, which makes things move more quickly. So a big part of giving it priority that it's required to receive by law is making sure that there are technology and means in place to actually hear people and hear them quickly.
Thank you. Mason Treneman?
Children's cases absolutely get priority. I want to go back to family court because of those babies, and I'll call them babies until they're 100. So if the question is, are you going to deal with babies or are you going to deal with dollars? You deal with the babies. The judge does that through docket control and being prepared. There are some divisions, in order to get a half-day hearing, we're now 6 months out. Respectfully, while I may like that judge, that's too long to have to wait. The judge can do it differently, I know, because I did it for 4 years. I did that through docket control. I read every single case file that ever came before me on my circuit docket before that case came before me every time. I kept my notes in an individual file, and I reread them every time, and I read the new filing since that time, and I kept, quote, control over the docket. I gave quick dates and handled things quickly. I was the first one to institute reviewing motion hour ahead of time. And I'd sit there on the phone on Thursday afternoons and call attorneys and tell them, here's what I'm thinking beforehand. So yes, children's cases need to be heard, and I know how to do that.
Thank you. Judge Russell?
Well, how can you agree with that? Of course, custody cases have to be heard, and it's a priority. One of the things that I'm doing is during motion hour, that's every Monday for every single division. And when people have a motion, I know what those motions are about because I too have read those. And I will tell you that with custody things, those are some issues that you can decide from the bench. Yes, there are some things that absolutely have to have a hearing, but if you go ahead and make decisions from the bench, it works, and you can reduce your docket. But what you don't understand is that or you may, if you've looked at the statistics, but there's about 2,500 cases per year per judge. That does not include items that are already existing, the repeat families that you see over and over again. And so, and every day is not dedicated to custody matters. It can't be. There's a domestic violence day that I've talked about on Thursday. There's the DNA, the dependency, neglect, and abuse docket that's on Wednesday. So you have about Monday, Tuesday, and Friday to deal with those. But if you make decisions from the bench at motion hour, you can help your docket a lot, and that's what I do.
Thank you. Jessica Stone?
So I think we all agree that custody is a priority. The difference is that I have a plan. I have been a litigant in the system, and I know what can go wrong. When you have a hearing, which probably is 6 months out, like they're talking about, and has probably been passed once or twice already due to who knows what, but the judge, that's on the judge that allows that to happen. You've taken off 3 days now, you finally get your hearing, and you go home with nothing. And you're told you're gonna get an order here in a couple weeks, and then you end up waiting and waiting and waiting. That's not priority. Priority is giving the litigants that came before you, that paid an attorney, that took off work and found a sitter to be there before you, giving them their hearing, and then giving them an answer. That will prevent frivolous and extra litigation, save money, and put the attention on the kids where it should be.
Thank you. Claudette, the next question starts with you. Should a guardian ad litem be appointed in all custody cases? Why or why not?
A guardian ad litem is the attorney that is appointed or appointed to represent the children as the attorney. That's what guardian ad litem means, or is referred to as the GAL. No, guardian ad litem isn't necessary in all cases, because there are many cases that come before the court that have gone through a mediation process, or the parents, excuse me, they have already made agreements and they are not contesting, or they do not have a custody dispute. So in those matters, no, a guardian ad litem would not be necessary. But where it's very important to have a guardian ad litem is when parents are in conflict over custody and they have made the child the weapon in their divorce and custody, and the interest of the child must be maintained as the best interest of that child, and they need proper and adequate and aggressive representation.
Thank you. Emily Craddock.
My answer is it depends on the docket. So in a civil case, a divorce case, a custody case, not every case is going to need a guardian ad litem to represent the interests of the children. There's a lot of cases where the parties are able to agree on what's the best schedule, what's the custody arrangement going to be for their children. And in that situation, I don't think the parties need that additional cost. There was a recent case this year that came out, and so on the domestic violence docket, anytime an emergency protective order is issued on behalf of a minor child, there's now supposed to be a guardian ad litem put in place to represent that child, which just makes sense because that child has either witnessed or been a victim themselves of domestic violence, and so they need their own attorney in person to represent them in that action. So on the DVO docket, yes, to follow the law. On custody and divorce actions, I think it's more dependent on each case by case basis.
Thank you. Mason Treneman.
A GAL is just not required in all custody cases. The old saying is that in custody cases, you either have two really bad parents or two really good parents. I don't think that's true, but that's one thing that people say. Certainly in those really bad cases, yes, that child needs a voice. When you have two good parents who are working through things, as others have said, you don't need to waste those assets because this process is expensive enough. But at the end of the day, when you have people who are knife and dagger against each other, and they're saying horrible things about each other and how they parent the child, mom has money for her attorney to represent her position. Dad has money for his attorney to represent his position. The most important person in that process is the child. And if the parents have money to fund their private battle, then they have money to pay for an advocate to represent the interest of those children. And that should be required in all of those type cases.
Thank you. Judge Russell.
In civil custody cases, not every case needs a guardian ad litem. In the hotly contested one, they absolutely, it's helpful, but there's also the friend of the court, and that's very helpful to the court because that's someone that really investigates, talks to both parents, if the child's old enough, talks to the child, collaterals, and makes a finding report to the court. But guardian ad litems do play a critical role, especially in the domestic violence docket. Every single time there's an emergency protective order on behalf of the child, I do appoint a guardian ad litem, and sometimes we need them and sometimes we don't, because once the guardian ad litem gets involved, they realize that the child really had nothing to do with, they weren't involved in the domestic violence that happened, they didn't see it happen, they just, you don't need them. So the guardian ad litem really determines whether or not they actually need to have a hearing, take testimony with respect to children. So the answer is, it really depends. Isn't that a great lawyer answer? It just depends on the facts of the case.
Thank you. Jessica Stone.
It is a great service. That and the front of the court can benefit cases where kids' safety is a question and an issue. There are cases, and a lot of times, high conflict divorce. It only really takes one person. One person can create that conflict, and that's what a lot of courts and judges don't understand, that you may see two people fighting or potentially before you that are litigating and spending all this money or having to spend all this money, but a lot of times it's just the one person, the one non-rule follower that is dragging that other person into court. So to add a friend of the court expense, it's just not necessary in those types of cases.
Thank you. Allison Spencer Russell.
We should appoint Jim Murphy in every single child custody case. That's an inside joke for people who regularly practice family law. No, just to echo everyone else. Not every single case merits a guardian ad litem. Not every single case merits a friend of court or a custodial evaluation. Some things are pretty clear cut. You just play it by ear. You just have to make a common sense judgment, and you also have to take finances into consideration because GALs aren't cheap. You know, it's another attorney on the case that the parents are paying for. So I just have to agree with everyone else on that one.
Thank you. Emily, we're going to come back to you for the next question. And a lot of people represent themselves in family court. How will you make sure that they understand the process, what is expected of them, and ensure that their needs are met?
Sure. So people that self-represent themselves, they're called pro se litigants. And surprisingly, or maybe not surprisingly, a lot of family law cases, people choose to represent themselves in their divorce action, their custody action, and so with those parties, you can't give them legal advice as the judge, but you can slow down, you can make sure that they understand the process, that they understand they have the ability to get an attorney, and to really make sure that everything is explained to them. For instance, saying, you're a pro se litigant, this is what that means, right? You're asking for this. Can you clarify, do you mean you want custody? Do you want parenting time? Those are two different things. And a lot of times people that represent themselves do not know those differences. And so I think a lot of it just comes down to making sure that you give them the time and the attention that they need so that when they leave the courtroom, they feel like they were heard, they were understood, and then they had the opportunity to present their case.
Thank you. Mason Treneman.
Respect and patience. People need to know they've been listened to. If they walk out of that courtroom and the judge was not patient and kind, and that's not to say that we're not firm, because judges need to be firm and enter orders, not make suggestions, but we also need to be patient and kind. If they walk out and know they had a fair shot at that hearing, regardless of whether they won or lost, they're going to feel a lot better about the situation. You can't give a pro se litigant legal advice, but the judges really need to help sometimes with the processes, the procedures, the definitions. We're here to fight for custody, Judge, and when you talk with them, no, it's actually a parenting time dispute, which is a very different thing. Judge, we don't know the next steps. I can't give you legal advice, but here is the pro form that you can use to take the next step, and by the way, here is the next step, and educate those on the next steps. And the last thing is that many pro se litigants also are English as a second language or no English at all. We have to be patient with the translators, and we have to make sure that the translators are accurately translating. I've been in court when that's not the case, and sometimes you just know that. Make sure the translations are correct as well.
Thank you. Judge Russell.
So when I first took the bench, I was unaware of how many pro se litigants we really have. And so I heard a statistic not long ago that about 80% of litigants are pro se. And I can tell you that's what I found. And so while I can't give them advice, I certainly do open up the forum for them to have to be heard, and I'm really trying during that hearing to come up with a solution for them so that they know how to move their lives forward. With 2,500 new cases every year and all of these existing cases, it is really overwhelming with pro se litigants. But it is important that they be heard, and that is certainly what I do every single day on every single docket. And by this point, people are actually I have some really great pro se litigants who are prepared with evidence, and they have wonderful questions. So I think maybe these TV shows are making a difference. I don't know, but some of these pro se litigants do a really good job representing themselves. Of course, you know, attorneys are awesome too.
Thank you. Jessica Stone.
I, as I mentioned earlier, as a prosecutor, deal with pro se litigants every day. And it isn't just about, of course, being respectful and being patient. Those are all things that go without saying. It is a lot of times going that extra step and going above and beyond what is expected of you in your role as a judge or a lawyer. It is giving them, showing them resources that are available to them, and yes, walking them through it, but also preventing any extra things that they might have to spend money on because they don't have the money to have an attorney. So they're not going to have money. The default, it seems, is to refer people to mediation. Well, mediation costs money. So why on earth would you be there or tell someone that they need to go to mediation when they can't even afford an attorney? So things like that would be very helpful to pro se litigants.
Thank you. Allison Spencer Russell.
So I think a lot of it boils down to just people skills. You have to be a special breed of human to do family law, and certainly to be a family court judge, you have to be blunt, but also compassionate. Seems like two weird things to go together, but tough love. Nothing bothers me more than I walk into the courtroom, and somebody is there and they say, "Are you an attorney? What does this mean? What is this paper? What do I do? Where do I go?" I think the court system has a long way to go when it comes to accommodating pro se litigants. They don't get the pre-rulings every Thursday, so these are people like Claudette was saying who leave work, drive downtown, only to find out that the judge has said, "Come back in 3 months for your hearing." And so that can be very frustrating for these people. And I think really I pride myself on being a compassionate human being and a patient human being, and I just think that it comes down to the personality of the judge.
Thank you. Claudette Patton.
A judge has to have compassion and empathy, and our pro se litigants, they need us to be compassionate and understand that they don't understand everything that we have and the lingo. For example, we have often set up here today DNA case. A pro se litigant was in the hallway the other day and went, "DNA? I'm not here for a DNA case. I already know that I'm the dad, so I don't need DNA court," when the pro se litigant may not understand the terminology or our acronyms that DNA is really dependency, neglect, and abuse, which meant the cabinet and child protective services. So I think the judge on the bench has to have someone of the staff who's in the waiting room, who's waiting outside. Are they there for the proper court? Are they there with their necessary documents? And also have the staff have a resource list that's available for the pro se litigant of all the things that they can access that an attorney may have access to that they don't know about. And I think we can also do a little better downstairs. Some of our clerks have people fill out pleadings and petitions for the wrong court, for the wrong case, over and over and over, and the judge cannot give advice, legal advice, but they keep coming back because no one is there giving them the right resource.
Thank you. So my last question is a little bit more personal, and I know everybody has had a chance to answer one question, but I do want to start with Judge Russell on this one. And many of you may have already read, I interviewed Judge Tara Hagerty when she retired about why she retired, because like I said at the beginning of all this, we really shouldn't be here a year later. We should have everything set. Family court ran unopposed last year, everyone. So here we are. And what we learned from Judge Hagerty was that it was a stress-induced medical emergency that led her to retire. So what I want to know from you is how will you handle that we do have very wide gaps in our system here in the state of Kentucky when it comes to serving our families in family court? How will you reconcile that within yourself while also doing your job which has got to be one of the hardest jobs in the world, to see families, not just people on their worst day, but families going through their worst crises. So how do you and how will you manage that to the benefit of our county and also to the benefit of your personal health?
So that's a really great question, Bonnie. You did a good job with that article in the CJ about Judge Hagerty. I didn't know the extent of her health concerns, but I will tell you, and I'm going to be perfectly honest with you all, this is a hard job. Being a family court job or judge is hard, and the things that I see, the things that I hear, it is really hard on me personally. But and I'm campaigning too, and I'm here tonight too, and I'll go back tomorrow and do my job. But it's difficult. But I think that I've practiced law, I've practiced family law for so long that I know that families need me to be centered. They need me to hear them and make a decision to move their lives forward. If I had time, I'd do a lot more exercising. I'd probably eat a little bit better. Maybe one day I can get back to that. But you know, we're really fortunate to have a family court. At least we don't have our circuit court, who's also dealing with murder cases, here in our family court cases. And so we have a lot of services. We've talked about services here tonight. Family court, I have a case manager who goes out and talks to the pro se litigants. She talks to the domestic violence victims. She prepares them for what's coming next. And so this is a tough job, but if you're compassionate about families, love families, and you either love them or you either love this job or you don't, and I really do.
Thank you. I appreciate that. Jessica Stone.
So I have a lot of practice handling stress. I'm a prosecutor. That's what I do. I'm a single mom. And I've also been drugged through the family court system. And the stressors that add to the already stressful life, a full-time working single mom, and having to confront, the other side, every few months is stress that I've had to deal with and manage, so I have a lot of practice. And I have found those outlets, yoga, ballet, finding your me time, a long hot bath. Like, yes, you need to have that self-care enough, and once you find your things, keep doing them. Don't stop just to, finish that last brief or finish, reading the last motion that came before you. Take a break, stop, and then tomorrow's a new day, work on it again. Thank you.
Thank you. Allison Spencer Russell.
I've asked some retired judges for advice on this, and all of them kind of uniformly said you need to find some physical activity or some way to purge any stress at the end of the day. Retired Judge Deanna McDonald specifically took up horseback riding. So I'm a hockey mom, and I've taken up figure skating. I'm trying to take up figure skating is the operative word there. And so I took that advice, but also I've done this area of law for so long. I've worked my way up from associate to partner at a large law firm. I run my own successful practice. There's nothing that can't be thrown at me that I haven't dealt with already in my daily practice. So I think just having that experience is going to help me kind of deal with the stress on top of just listening. I mean, Tara Hagerty, that was a tremendous loss to the bench. She was fantastic. So to hear that she was having those problems was really concerning. But again, I think I manage it daily. I can continue doing it.
Thank you. Claudette Patton.
First, I want to thank you for your article. It was not only a great article about Tara Hagerty, but it was a great article about the status and the condition of family court and the gap in the services that we have for our families and our children in this community. And I have been talking to anybody for the past 13 years who will listen that we must fill in these gaps. And that is one of the greatest stressors among judges, that judges are making decisions of where children are going to be placed. And the child that we place in the custody of the cabinet suddenly is sleeping on the floor of the L&N building, and that has been rejected from 71 foster homes and has no place to go. That's a heavy burden to weigh upon you as the person who is making decisions in children's lives. But as any lawyer or any judge, we have to have a well-being program. I've been a proponent and an advocate for the last 7 years in promoting attorney and judicial well-being with our lawyer assistance program. We must have well-being. It's individually based. We must remain healthy so that we can be healthy for our families and the community.
Thank you. Emily Craddock.
I think that it is critically important for the judge to be in a position and in a state of mind to make clear, rational decisions, and that means making sure that you're taking care of your own mental health and your own physical needs. When I was about 8.5 months pregnant with my first daughter, I had a case on the neglect and abuse docket that was a near fatality case of a child. And it was upsetting to me. I mean, it would be upsetting to anyone. And I had to really step back and evaluate how I was handling that stress and internalizing it within myself. I took up meditation that very day, and I can tell you I meditate for about 30 minutes every single morning. That's a big means for me to reduce stress and make sure that I'm focused. I play beach volleyball with my husband, but it's finding that outlet, right? And making sure that at the end of the day, you're able to, kind of walk away and start each day fresh again, especially on a day when there's a particularly heavy issue on the docket.
Thank you. Mason Treneman.
As a former family court judge, I know you do have to take care of yourself and find your outlet. My outlet is my family, my wife and my then 2 kids, now young adult children. And then at the end of the day, besides loving your family and knowing how blessed you are, you need to do the best you can do, and you need to make decisions that you believe are in the best interest of the family based on all information you have. I had a case on the EPO docket where the parties came in and dismissed the EPO, and about 3 weeks later, it was a murder-suicide. When I saw the names in the newspaper, I said, please, Lord, I hope I didn't miss anything. I went back, I looked at the docket, I read the paper, I called people. Fortunately, I did not. They came into court with 2 lawyers. They voluntarily dismissed the petition. The neighbors said they were in the yard 15 minutes before this happened, planting a rose bush, and seemed happy as could be. So nothing was missed, thankfully. But I know other judges who that happened to or something similar, and they missed it. You know that's a risk, but you do the best that you can do. And at the end of the day, what brings you through is your faith and the knowledge that you're trying to do the best you can do in this system.
Thank you. I appreciate all of you being here. Those are the last of my questions. We're going to take 90 seconds again and go down the line. Any final thoughts? Something I forgot to ask? Something that you've been wanting to say, but just the question wasn't right? Now's your chance. It's 90 seconds. This time I'm going to start with Claudette Patton, and we're going to go backwards this way for final comments. That still puts you right in the middle for the 2 of you in the middle, but there we go. So 90 seconds. Claudette Patton.
Thank you. Thank you to all the sponsors. Thank you for all the voters who are here. Thank you for these wonderful students that are in the pre-law program for providing us with this opportunity. But my most important thing is I want to thank all of the voters in this community. This has been the opportunity of a lifetime. I have had the greatest time campaigning for this position of judge, and I would not trade one moment of this time and this space. Thousands and thousands of voters have asked me questions, wanted to know who I am, what I would bring to family court, and wanted me to listen to the things that were important to them. Standing on their porch steps, invited into their kitchens, potluck dinners, community outreach programs. Just thank you for your civic duty and involvement, because your vote is the strength of our democracy. And I just want to end by thanking you for giving this girl who grew up in Fairdale this amazing opportunity and the opportunity to be your next family court judge, because I am ready for this task, and I thank you for your confidence.
Thank you. Allison Spencer Russell.
I've had the privilege of making law in Kentucky. I've argued in front of the Supreme Court and the Court of Appeals numerous times. I have several published cases. I've made law in the area of grandparent visitation, attorney's fees, evidentiary issues, a lot of different things. Recently, I won an appeal relative to parents' rights in step-parent adoption actions. And so getting the law right, the first time, and writing a good, solid order that is appeal-proof, adjudicates the rights of the parties, and is done expeditiously is one of my primary things I'm using as my platform, because I can do that. I love writing. I started off my career working for a judge, writing all of her orders, observing her manage her courtroom docket, observing her delegating tasks to different staff. And it was right then that I knew I wanted to continue doing something where I could write orders, and I wanted to be a judge someday. And, thankfully the seat came up, and I've had 14 years of experience. I don't dabble in family law. This is what I do all day, every day. This is what I breathe, is family law. And I would just love the opportunity to serve the citizens of Jefferson County, to serve as their next family court judge.
Thank you. Jessica Stone.
So I know I've talked a lot about my life experience and that perspective that I'm bringing to the bench, but I do want to stress that every setback or roadblock that I perceived in the moment being just that has actually been a stepping stone that has prepared me to sit on your family court bench. Professionally, my experience outside of owning my own solo practice previously, the last 7 years I've been prosecuting. And as a prosecutor, my goal is to pursue justice. And that doesn't mean putting people in jail, doesn't mean getting people arrested or pursuing unjust crimes. What that means is that every day I look to be fair, equitable, and to define justice. And that is what makes me your best choice for your next family court judge.
Thank you. Judge Laura Russell.
Well, I want to thank all the sponsors. I want to thank the pre-law students. Make sure you know what you're getting into as well. But I want to say that Governor Beshear gave me one of the highest compliments. He allowed me to serve the families of Jefferson County, and that's what I've been doing for the past 5 months, and I think I've been doing a really good job. I've practiced family law for 15 plus years. You either love family law or you don't love it. I love it. I came to the bench not for the title of judge, but for the opportunity to serve families. I have a wonderful staff. Couldn't do without them. I've worked with so many other people during this process to make family court work for Jefferson County. And if you give me your vote on November 7th, I will make you proud with that vote. I will continue working for families every single day. I will continue listening to families, and I will continue helping domestic violence victims and fighting for resources for our children when they are removed from their home because of abuse and neglect. So I'm asking for your vote on November 7th to keep me Judge Laura Russell, and to continue the good work that my team and I have already been doing for the families and residents of Jefferson County. And I will tell you, as a wife and as a mother, as a swim mom, I love this community, and all I really want to do is make it better, make it great, and serve the families. Thank you.
Thank you. Mason Treneman.
I am Mason Treneman, and I'm here to ask for your vote, those who are here in person and those who are here by video, when selecting a family court judge. I think there are two primary things to consider. The first is qualifications. I've practiced law for 36 years. I think that's something that's important. We need to choose seasoned people who know these systems and know these processes. 5 years as a family court judge and district court judge. Before that, I was blessed to serve as an assistant Commonwealth attorney and county attorney. I prosecuted everything from child support to murder PFO1, from the little stuff to the biggest stuff there is. I was an administrative law judge with Kentucky OSHA, assuring safe workplaces for the people here in Kentucky. When a family court judge, I co-founded Adoption Wednesday. We performed over 100 adoptions, almost 100 adoptions in a single day for kids who were just languishing in care because nobody had the time to deal with them. I was also involved with the National Council of Juvenile and Family Court Judges on the dependency, neglect, and abuse docket. The second factor is the heart for service. When I looked up and down my street, drove down the street I grew up on not long ago, there weren't any doctors, there weren't any lawyers, there weren't any professionals. More kids on my block went to jail or the penitentiary than went to college. I'm not a first-generation college graduate, I'm a first-generation high school graduate. We've had 7 foster babies in our home who were drug exposed and medically fragile. I've worked for CASA on the board. I've been on the board with Habitat for Humanity. I've cleaned, I've scraped, I've painted, I've fed. I give back to my community. I think that family court is the way that lets me cast the longest shadow and continue to give back to my community. I'm Mason Trenham, and I hope you agree that I'm worthy of your support, and I ask for your vote.
Thank you. Emily Craddock.
Yes. So I'll repeat, I'm Emily Craddock. In case some people ask, I'll trickle in and obviously might be joining the live stream a little bit later. I want to be the next family court judge because it is what I am passionate about. I've known that I wanted to be a family court judge since my parents got divorced when I was a child. And I went through that system through the eyes of a child and was able to see and appreciate how traumatic it can be from a child's perspective. And that really drove me into this area of law. I feel right now as an attorney that I can make an impact, and it's like this big. As a family court judge, you can make a tremendous impact because you can reach so many more people, so many more parties. So right now, yes, I'm happy. I love that I'm helping 50 to 60 families at a time, my clients at a time. But as a family court judge, you have such a much broader reach than you otherwise would as a family law attorney. Speaking to experience, I've done only family law since I first started practicing in 2014. I appreciate I'm young. I'm probably the youngest up here, but that doesn't mean that I'm inexperienced. I think that I've done all the different dockets, which I think distinguishes me, and I did just family law, so I've not done something where I'm splitting my time with another practice area. And so I might be the youngest up here, but I don't think that means that I don't have the depth of experience necessary to be a judge. So I'm Emily Craddock. I'm asking for your vote this November. Thank you.
Thank you. Thank you very much, everyone, and I'm so glad to see so many people here tonight. And for everyone who is watching on the live stream, you'll be able to watch it again if you would like to. And a special, special thanks to Seneca High School for being our host this evening and making this wonderful space available for us to have this very meaningful conversation for our community. And the biggest thing is you're here, so you care, so please don't forget to vote. Just make sure you go out and vote. And for those of you who want to take a tour of the academy, you can meet over here by the banners, and they will show you the courtroom that is here in the school and the special for their special program. And again, I'm Bonnie Feldkamp I'm the opinion editor for the Louisville Courier Journal, and thank you all very much for coming out tonight. I appreciate it.